Apple fights order to unlock San Bernardino gunman's iPhone. Welcome to the Shakaama Live Show with your host, Shakaama. Last month, some of President Obama's top intelligence advisors met in Silicon Valley with Apple chief Timothy D. Cook and other technology leaders in what seemed to be a public rapprochement in their long-running dispute over the encryption safeguard built into their devices. But behind the scenes, relations were tense, as lawyers for the Obama administration and Apple held closely guarded discussions for over 2 months about one particularly urgent case. The FBI wanted Apple to help unlock an iPhone used by one of the two attackers who killed 14 people in San Bernardino, California in December, but Apple was resisting. When the talks collapsed, a federal magistrate judge at the Justice Department ordered Apple to bypass security functions on the phone. The order set off a furious public battle on Wednesdays between the Obama administration and one of the world's most valuable companies in a dispute with far-reaching legal implications. Before I go on, for those who are in the conspiracy community, of course it stands that the particular gunman was in fact not a gunman, or it was a false flag. And for those of you who don't know what a false flag is, please go look up what false flag is. I know a lot of times you hear words that you don't understand and you take them literally. False flag does not mean people did not die and that people did not shoot. That's not what false flag means. It means something completely different. It is a political maneuver. Quote, "This Apple case really goes right into the heart of encryption issue," said Ira Rubinstein, a senior fellow at the New York University Information Law Institute. And in some ways, this was a fight that was inevitable. This is not the first time technology company has been ordered to effectively decrypt its own product, but industry experts say it is the most significant because of Apple's global profile. The invasive steps, it says, are being demanded and the brutality of the San Bernardino attacks. Law enforcement officials who support the FBI's position said that the impasse with Apple provides an ideal test case to move from an abstract debate over the balance between national security and privacy to a concrete one. The FBI, and that is the crux of the entire indication that this was a false flag. Now, for those of you who do not believe that the government can orchestrate 12 steps beforehand, that they cannot orchestrate somebody shooting people, and that person has in their possession at some point specifically an Apple iPhone, and that they will come to heads against Apple, ask them to decrypt their Apple phone, have Apple deny such a request, take it to a judge in the Department of Justice, and have that judge order them to decrypt it, and then use that as precedent to thereby, from then on, order all companies to decrypt phones, devices, any time the government requests it. If you don't believe that the U.S. government can orchestrate this, you are naive beyond measure. Magistrate John Sherry Pym of the Federal District Court of the District of Central California issued her order Tuesday afternoon after the FBI said it had been unable to get access to the data on its own and needed Apple's technical assistance. Mr. Cook, the chief executive of Apple, responded Wednesday morning with a blistering 1,100-word letter to Apple customers warning of the chilling breach of privacy posed by the government's demands. He maintained that the order would effectively require it to create a backdoor to get around its own safeguards, and Apple vowed to appeal the ruling by next week. Quote, the same engineers who built strong encryption into the iPhone to protect our users would, ironically, be ordered to weaken those protections and make our users less safe, Mr. Cook said. Now, if you have been paying attention and following along, I'm not talking about this Apple case. I'm talking about, period, going back to Bush and how the NSA required Microsoft to put backdoors into everything that Microsoft has. Yes, you are wide open using Microsoft products. You are wide open. Allegedly. so I don't get sued. Allegedly, you are wide open. Apple argues that the software the FBI wants it to create does not exist. But technologists say the company can do it. Mr. Cook's angry tone reflected the tense discussion conducted mostly on the telephone between his company and the government's lawyers over the San Bernardino case. Apple executives had hoped to resolve the impasse without having to rewrite their own encryption software. They were frustrated that the Justice Department had aired its demand in public, according to an industry executive with knowledge of the case who spoke on the condition of anonymity about internal discussions. His vote of confidence was significant because James Comey, the FBI director, has at times been at odds with the White House over his aggressive advocacy of tougher decryption requirements on technology companies. While Mr. Obama's national security team was sympathetic to Mr. Comey's position, others at the White House viewed legislation as potentially perilous. Last year, Mr. Obama refused to back any legislation requiring decryption, leaving a court fight likely. Coincidence? The Justice Department showed no sign of backing down Wednesday. Quote, it is unfortunate, the department said in a statement, that Apple continues to refuse to assist the department in obtaining access to the phone of one of the terrorists involved in the major terror attack. This is not a major attack. He's not a terrorist. It's not a major attack. 14 people died. This is stupidity at its worst. 14 people die is not a terror attack. More people die in a single car accident. Using a gun to shoot people and only 14 of them die is not a terror attack. It's not even a mass shooting. Go look it up. He's not a terrorist. This wasn't a terror attack, and it wasn't a major U.S. terror attack. They're always throwing around these words just so that they can have their way. Oh, well, it comes to national security. No, this guy shot people. There's nothing national security about it. No, absolutely nothing. The dispute could initiate legislation in Congress, with Republicans and Democrats alike criticizing Apple's stance on Wednesday and calling for tougher decryption requirements. Donald J. Trump, the Republican presidential contender, also attacked Apple on Fox News, asking, who do they think they are? But Apple had many defenders on its own among privacy and consumer advocates who praised Mr. Cook for standing up to what they saw as government overreach. Let's talk about government overreach. Do they really need... Why do they want to get into the phone? Because they've created this premise that this was a terror attack. Now, if Tyrone got out his 2 guns... I don't know anything about guns. But I'm assuming 14 is going to require 2 guns, right? If Tyrone got out 2 guns and started shooting up the hood, are they going to call that a terror attack? No, they're not, because it's not a terror attack. But they create this premise that, oh, this was a terror attack And because it's a terror attack, it falls under national security. And because of national security, we then need to get into his phone to check to see if there's other terrorists. He's not a terrorist. This wasn't a terror attack. It wasn't a major terror attack. Lie, 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 lie. So you can create this precedent to then be able to get into anybody's phone at will, to create a backdoor at will. If you have been paying attention, there I go again saying that, and I don't mean this case. I want you to go back about 3 to 4 years when they started coming out with encrypted phones, encrypted devices, and the government screamed, the Obama administration started screaming, why are you coming out with encryption? Because we don't want people to get into our phones. We don't want people to get into our devices. Why? Because the Supreme Court has says you don't have a expectation of privacy in the public. If you're using your phone in public, you have zero expectation of privacy because any Tom, Dick, and Harry can walk up and listen to your conversation. Now, mind you, if any Tom, Dick, and Harry walked up and started listening to your conversation, you could punch any Tom, Dick, and Harry in the nose and say, get away from me and stop listening to my conversation. I expect to be private over here. Unlike Shaniqua, who gets on the public bus and has her complete conversation screaming match with her phone being held 3 feet from her face, most normal people actually speak in whispered tones so that only the person on the phone can hear them. The public expects to be private. So they came out with encryption so that you couldn't just hack into their stuff willy-nilly. I don't know how good the encryption is, but we're expecting, because of the encryption, for our privacy. And quite frankly, either we have a right to privacy or we do not have a right to privacy. Do you understand what a right to privacy is? Now, I know you have been conditioned by the past, 20 administrations or so to not understand what a right to privacy is, nor a right to freedom of speech. Do you understand that the founding fathers thought they were writing rights, meaning that no matter what, you could not infringe on those rights? Now, the Supreme Court, which has been taken over by partisan politics, and now we have people sitting on the Supreme Court who don't translate the Constitution. They apply their partisanship to cases. That's what's going on. There's no longer the Supreme Court. It's just party hacks sitting on the bench. But had you had an actual judge sitting on the Supreme Court, they would have been dismissing cases left and right. No. You don't get it. The person has a right to privacy. Now, I can't recall the case, but the police were trying to get into a man's briefcase, not cell phone, briefcase. They had the man arrested. The briefcase was in the trunk of the car, and they said, no, you don't have a right to get into the man's car, briefcase. I cannot recall the case. Trying to look that case up would be quite a pain, but let's continue here. This is not the last step in the journey, said Robert Kadanak, a former Justice Department lawyer who works on privacy and tech security issues at the law firm of Dorsey and Whitney. Quote, the next thing you know, they'll be in the back door of these systems, which is exactly what I said, right? Once they open it, once they create a back door, they're going to say you do not have an expectation of privacy on your device because the back door was created. The back door was created, ergo, vis-a-vis, concordantly, you should not have an expectation of privacy at all on your device. Now, this is why I brought up the suitcase case. The court held that you have a right to privacy. And that even though it's the government and they have him in custody for running a red light, that doesn't mean that they can willy-nilly go into stuff just because they're curious. And the government literally is saying, we're going to put our trump card on the table. And what's the trump card? National security. That's their trump card for everything. National security. This is a matter of national security. What do you mean it's a matter of national security? Well, we're going to require you to close your business. What is my business being open? Yes, they have used this. Do you understand? Do you see? I feel like the South Park guy. Do you see? We want you to close your business because of national security. We're coming into your house because of national security. Why do you have to come into my house because of national security? Because your house is situated across the street from people that we think are a security threat. So we're going to move you out of your house and take over your house. Do you have a warrant to come in? No, we have national security. Let's continue. The Apple order is a flashpoint in a dispute that has been building for more than a decade. I've told you. Have you been paying attention? The FBI began sounding alarms years ago about technology that allowed people to exchange private messages protected by encryption so strong that government agents could not break in. In fall of 2010, at the behest of Robert S. Mueller III, the FBI director, the Obama administration began work on a law that required technology companies to provide unencrypted data to the government. Lawyers at the FBI, Justice Department, and Commerce Department drafted bills around the idea that technology companies in the internet age should be bound by the same rules as phone companies, which were forced during the Clinton administration to build digital networks that government agents could tap. Do you hear this? Do you see? The draft legislation would have covered app developers like WhatsApp and large companies like Google and Apple, according to current and former officials involved in the process. There's no debate that when armed with court order, the government can get text messages and other data stored in plain text. And I know because I worked for Cox and that was part of our training. They said, if you get a phone call, you will comply. If you get a phone call from the government, you will comply with the government. Far less certain was whether the government could use a court order to force a company to write software or redesign its system to decode encrypted data. A federal law would make that authority clear, they said. But the disclosure of government surveillance by Mr. Snowden changed the privacy debate. And the Obama administration decided not to move on the proposed legislation. It has not been revived. The legal issue raised by the judge's order are complicated. They involve statutory interpretations rather than constitutional rights, and they could end up before the Supreme Court. For you, let me just finish this. As Apple noted, the FBI, instead of asking Congress to pass legislation resolving the encryption fight, has proposed what appears to be a novel reading of the All Rights Act of 1789. The law lets judges, quote, issue all writs necessary or appropriate in aid of their respective jurisdictions and agreeable to the usage and principles of law, which sounds like a bunch of nothing, right? The government says the law gives broad latitude to judges to require third parties to execute court orders, which is not what it says at all. It has cited a 1977 ruling requiring phone companies to help set up a PIN register, a device that records all numbers called from a particular phone line. Apple argues that the scope of the act has strict limits. In 2005, a federal magistrate judge rejected the argument that the law could be used to compel a telecommunications provider to allow real-time tracking of a cell phone without a search warrant. Thank God for that, Judge. Now, for you who have been indoctrinated into the system of the government is all-powerful and that your constitutional rights have no bearing whatsoever, I'm here to tell you, the founding fathers thought when they were writing, you have a right to. It was done, deal, signed, seal, delivered, it's yours. So when they say you have a right to privacy, they thought they meant you have an immortal right to privacy that come hell or high water, nothing anybody could do, because they already lived under a very fascist sort of king where the guards could come into your house, come inside your house, do whatever they wanted inside of your house, look through your papers, take you, pull you by the hair, throw you out, and arrest you willy-nilly just because it was a Tuesday. They lived under that. So when they wrote, you have a right to privacy, they thought everybody understood by that you had an unending right to privacy. It didn't mean that when the government got good and ready that they could come and take that right away. Who was the right against? The right was against the government. So why would they write the right so that the government could bypass it? The whole point was the government could not bypass any of these rights. No gun registration, no application, no 90 days waiting period. All of the rights in the Constitution are supposed to be forever. Even if you got into a fight with Tom, Dick, and Harry, you don't all of a sudden give up your rights. This country, this government that you're under has so deflated your rights and then turned around and teaches you that that's what the government is supposed to do because of national security, because you could be a threat to your neighbors. You could be a threat to yourself. Okay, because he could be a threat to himself, we're going to rescind all of his rights. No, the rights are against the government. They're not against private citizens. If I wanted to sit here, have a phone conversation, and Joe Schmo wanted to tap and put a listening device on my window and tap and listen to what I say in here, now I could sue him for trespassing, but I can't sue him for violating my right to privacy. The right to privacy is against the government. That's it. And that's your defense, or that's your attack. Hey, I'm taking you to court. You violated my right to privacy, government. There's no like, well, we really have to get into his house. We really have to get at him. We really need to get into this closet. So we're just going to excuse this whole right to privacy. Okay, give me the key. No, I have a right to privacy. That's the whole point of it. Okay, do you get it now? It is forever. And no amount of, well, he shot somebody, so he no longer has rights. No, that's not what it means. Now, I know you have judges that'll say stuff like that, and I know you've been taught that, but that's not how it works. Now, I expect Apple to put up a valiant fight and then cave in. And then your phones will be unencrypted, and if you're stupid enough to stick with Apple, that's on you. Thank you for watching the Shakaama Life Show.